Section 11 provides for what is known as a program reserve fund. Before going to the details, can you give me the significance of providing a reserve fund for Philhealth? What is the importance of having a reserve fund for Philhealth?
As I understand, Your Honor, it's like a contingent fund.
A contingent fund for what purpose?
To address the possible lack of funding in the future.
So would you agree with me that the higher reserve fund you have, the more secure Philhealth will be?
Yes, that's correct, Your Honor. But at the same time, the law provides a mechanism so that
Within the mechanism provided for the actuarial.
yes, there's also a mechanism so that the managers of Philhealth do not become so conservative, so they cannot fix a reserve fund beyond the ceiling. There's a ceiling imposed by Section 11, Your Honor.
Okay, now let's go to Section 11. Section 11 speaks of accumulated revenues. It also speaks of reserve fund. It also speaks of current.
Right now, Your Honor, there is an office order issued by the Philhealth President in 2012 where accumulated revenues is defined to mean the accumulated income of
a mechanism in Section 37, the last paragraph says that the DOH and PhilHealth can provide the necessary, can request the subsidies to help it achieve the goals of the Universal Healthcare Act. So it's a continuous flow, Your Honor.
Yes, precisely. So the fact that PhilHealth could not spend this amount for benefits and the national government will take this amount to fund unprogrammed expenditures, the fault is on PhilHealth for not spending this. It is not for the government to take this away and for PhilHealth to expand its programs so that the subsidies that were allocated by government for healthcare should not be taken away. Instead of directing the DOF, the national government, directing PhilHealth, oy PhilHealth, gastusin niyo ito para sa taong bayan, kinuha ninyo at binigay sa iba. This is precisely the meat of this case. So, why is PhilHealth therefore not expanding their benefits and programs that would approximate the subsidies that were given to them to answer for the health benefits of our people?
Your Honor, if I may. So this is, of course, based on the discussions with management and my experience in the deliberation of the board. But fundamentally, PhilHealth faces structural absorptive capacity issue. What does that mean? The benefits, expansion of benefits is only one part of the equation. To accomplish the objectives of the Universal Healthcare Act, we need, the national government also needs to address what we term as the supply side constraints, supply side issues. So ano po ba ito, Your Honor? So number one, the insufficiency of the compensation for our healthcare workers or healthcare professionals. Number two, hospitals, healthcare facilities. Even if there is even if benefit expansions occur, if there is no hospital within the vicinity of a specific beneficiary, particularly an indigent beneficiary, then they will not be able to avail of these expanded benefits. So there needs to be the supply side constraints. And of course, in addition to the direct health, supply side health constraints, so yung hospitals po, yung medical equipment, and of course the personnel, the health care workers, you also have the WHO also has this term called the social determinants of health. So those are the other things. Those are the other things that help improve health outcomes. So what are these?
sorry, these things that you mentioned, absorptive capacity, the supply side issues, this can also be addressed by government. You're getting money from Philhealth and telling us that Philhealth lacks absorptive capacity. But the reason why it lacks absorptive capacity because it doesn't get full support from government, not only addressing expanding benefit, but also supply side requirements. So you're just providing an excuse to get this money out of PhilHealth. No, when you speak of limitations in hospitals, I mean, you can inquire from our people, repeated complaints that they cannot even get PhilHealth benefits. And if they get PhilHealth benefits, it's so low that it cannot even cover substantially the amount expenses or medical expenses. So people will not understand the issue of absorptive capacity or supply side demand or requirements. So on the issue of why do you need for these benefits?
Or the instruction to return the 89.9 billion, we have seen last year that PhilHealth has significantly accelerated the pace of benefit expansion, and they will continue to provide more benefits this year. So the issue in terms of the expansion of benefits is steadily being addressed.
Precisely, that PhilHealth increases benefits because of public criticism arising from this, trying to get the 89.9 billion. They are now probably justifying, oh, we can do this. In fact, we're increasing the amount. Without public backlash, probably, I don't know if PhilHealth will increase its benefits.
That may be so, Your Honor, but all the same, I think for the Department of Finance, for the economic managers, what matters to us is the expansion of benefits. If there must be a stick that must be presented together with the carrot, then we shall, I think we are happy if we see more benefits for the Filipino people.
Okay. Now, let us now go to the collection, the subsidy. The subsidy that were given to PhilHealth were taken from the taxes, as mentioned earlier by Justice Ami, taxes from PAGCOR, etc. Now, when the budget for PhilHealth subsidy from government, how do you compute the proposal of PhilHealth for subsidy from government? Let us say for 2024, so may budget call noong 2023. PhilHealth will have to prepare a budget, a request. For purposes of determining the subsidy that will be contributed by the government, what is your basis in determining the subsidy? Proposal to be submitted to the Office of the President for NEP.
Your Honor, if I may, I believe the exact process would be most familiar to DBM, but if you can allow me my basic understanding of the process. So PhilHealth during the budget deliberation period, they submit a proposed budget, and this proposed budget includes, number one, the number of beneficiaries.
No, initially, sa NEP pa lang. For purposes of preparing the NEP, the PhilHealth will submit to the Office of the President a budget. Part of that budget is the amount of subsidy for indirect contributors. How much do you ask for, and what was the basis for this amount?
Your Honor, if I may, I'm not familiar on the exact amount, but in terms of the process, I know I am to the best of my knowledge, the proposal of PhilHealth is put together with with DOH. So it's a DOH budget submitted to DBM for evaluation.
No, the reason why I ask this, we have laws that allocate funds to answer for the subsidy of government to PhilHealth. Mentioned earlier, syntaxes, etc., etc. Now, Do you know the actual collection of government corresponding to these taxes? And if you have computed this amount, do this equal to the amount PhilHealth requested Office of the President for purposes of subsidy for indirect contributors?
Your Honor, I do not have with me the exact certifications from the syntax
I need to get an
allocation.
answer to this because this is in relation to the question of a special fund. Yung collection ng gobyerno sa mga taxes, PAGCOR, etc., for the year, ito rin ba ang hiningi ng PhilHealth sa Office ng President para doon sa subsidy ng indirect contributors? For me, it should be the same amount.
I believe our colleagues from PhilHealth or probably DOH would be in a better position to answer this on the exact amounts, Your Honor.
Good afternoon, Your Honor. Assistant Secretary Albert Domingo from the Department of Health.
Yes, please.
Thank you, Your Honor. To the question on how the PhilHealth computes its request for a budget, it does not refer to the computation on the syntax allocation. Instead, it counts the number of members based on a database. There is a database on indirect members, and then it generates a list. It enumerates the number. The exact number escapes me now, but this is the process. And then that number is submitted, multiplied by a factor, which is the premium rate, and then it is submitted to the Department of
So
Budget
therefore,
Management.
when you come up with your budget request for the subsidy, you don't actually consider the taxes being collected that Congress passed for purposes of subsidy for indirect contributors.
That is correct, Your Honor. The budget is computed based on the need.
So they're not following the law? You're not observing what the law requires?
Your Honor, budget principles require that it's needs-based. If we will follow it based on the projected fund ceiling or availability, it might not match certain names.
Yes, I agree. It's based on needs. But the problem there is PhilHealth limits the funding so that you don't address the needs, the health needs of the Filipino people. If you increase budget 200%, and I don't think the Filipino would not avail of that. You define your own limits. The Congress allocates budget or collects taxes, provides for collection of taxes to answer for the subsidy of PhilHealth for indirect contributors. Now, when you request money for subsidy, ang ibig mong sabihin, hindi mo papakailam yun? Hindi mo naiintindihin yun? Gagawa ka ng sarili mong formula because you have limited understanding, there's a limited need of our people for health.
Your Honor, the current administration agrees with your observation, which is why this particular case under litigation has been the signal it has been using to increase the benefits. Ang tagal na po, 10
So
taon.
therefore, if the current administration recognize that, very thank you. And therefore, they should bring back the money back to PhilHealth.
Your Honor, the reason why the administration recognized it because for the longest time, the corporation has thought it will always get money because of the guarantee of the
Oh,
syntax.
precisely, whatever would be, whatever is that. As long as the government recognizes now, it is now incumbent on the part of the government to return the 60 billion that was transmitted already because it recognized now. Hindi lang na-recognize probably before, ngayon na-recognize na. So therefore, when you recognize it, you should return it. What do you think?
Your Honor, if it pleases the court, Section 58, the sovereign guarantee, even without this maneuver of the 89.9, government can and always will increase the benefits. But the signal, Your Honor, if it pleases the court, that this litigation gave is a strong signal for it to do so.
So the court, the people, should now be satisfied by a strong signal from the administration.
Your Honor, it's not necessarily the administration. It is the fact that the reserves, the
You
amounts...
said the government.
Yes, sir. Yes, sir.
So a strong signal from the government to help Philhealth and expand benefit should now be enough for our people to rely on.
This is the start, Your Honor. If the case is allowed to proceed, if the transfer is allowed to proceed, it is a use it or lose it signal, which all national government agencies have, so that we will use our funds. GOCCs like Philhealth do not have that signal, and they think, at least before the current CEO or the current administration, they think that just because there is an earmark, whether hard or soft, that they will get the money and there is no stimulus for them to actually increase the benefits.
When you prepare this budget of yours for subsidy, why did you not consider the collection made by government, by BIR, on the sin taxes? What was the reason behind that?
Your Honor, mathematically, it's the premium rate. The way that the premium rate is determined, unfortunately, is not actuarially fair. It is not based on the spread of benefits that is due the Filipino people. Kulang po talaga yung binabayad ng PhilHealth. 10% lamang po in 2024. Kaya dapat po talaga taasan. And mathematically, the only way to do this is to increase the benefit packages, which we are doing now.
But the government collected taxes already, representing supposedly the subsidy. Why would government not transmit everything to PhilHealth as originally intended?
That is correct, Your Honor. Unfortunately, the receptacle to which this money can be transmitted cannot handle the amount of money because it's too small.
So if it is correct, and the reason why it was not transmitted because of administrative matters or hindrances, you agree that this should go to PhilHealth. It's a matter of spending it. So therefore, when government merely allocated this amount, probably substantially lower from the taxes that were collected, all of the balance should be given to PhilHealth this year and prior years. It's just a matter of administrative absorption. Hindi lang kaya gastusin ng PhilHealth. Kung hindi kaya gastusin ng PhilHealth, ibigay sa PhilHealth at utusan ng PhilHealth, oy, taasan ninyo ang benefits nyo. Hoy, mag-hire kayo ng mga tao ninyo para magastos ito para sa health ng ating tao.
Your Honor, if I may, 3 presidente na po ng Republika ang dumaan simula noong 2013 hanggang 2023. At siguro mahigit 10 mga presidente ng korporasyon. Ganun po lagi ang utos pero hindi po nangyayari until now.
Probably it's time to overhaul PhilHealth and change the board for not complying what the law requires. Hindi kasalanan ng tao yan. For not availing all of these benefits. Apparently, from your own words, kasalanan yan ng administrasyon, this administration, last administration, or the previous administration. At kasalanan yan ng PhilHealth Board. Huwag natin pahirapan yung tao because nandyan naman yung pera. The money is there. Government will not giving it to PhilHealth to serve as health benefits for our people.
If I may, Your Honor, in fact, nung una pong oral arguments, iba po yung PCEO na humarap sa korting ito. At nung ikalawang oral arguments, ganun ho kabilis, iba na ho uli yung humarap na CEO. Kino-correct na po.
Okay, so that's maybe a good point from PhilHealth, but we cannot close our eyes for the past years na hindi nabigay in benefits. So in that case, maybe PhilHealth can already request the President to return the money, the 60 billion that were transmitted to PhilHealth, to the government for anchor program funds. Ibalik na yan sa PhilHealth, and PhilHealth to expand its benefits, hire more people to answer for the needs of the health of our people. That will be all, Chief. Thank you.
Thank you, Justice Ko.
Your Honor, please, if I may raise a factual matter, Your Honor. I'd like to, I'd like the court to know that PhilHealth has not been actually disadvantaged by its not demanding the allocation from the syntax law. Because in fact, I have here the numbers, Your Honor. From 2013 to 2021, PhilHealth has actually been receiving subsidy from the GAA more than what it would have received under its allocation attributed from syntaxes, Your Honor. For instance, in 2014, the PhilHealth allocation attributed from syntax is only 22.71 million, but the total PhilHealth subsidy was 35.34. So let us say in 2021, PhilHealth allocation attributed from syntaxes was 16.92, and the total PhilHealth subsidy was 80.24. So there is no truth, Your Honor, to the claim that yes, that's what I have
sorry,
here,
Chief.
Your Honors.
So, but you mentioned only syntaxes, but there are other sources of the subsidy aside from PAGCOR and etc. So when you total this, I would think it should be more than
By
the
the way,
subsidy because
yes, there is
you know government has limited funds. Kung ito lang ang collection under the law for subsidy, I doubt the government will allocate additional funds. So kukuha lang yan dun sa funds allocated under the law, whether PAGCOR, whether syntaxes, at dun lang kukunin yan. It could never be more than because government has limited resources. Saan niya kukunin yung balance?
These are numbers that I got from the from our Bureau of Treasury, Your Honors. And by the way, if I may mention, there is actually an interagency committee composed of the Department of Budget and Management, Department of Finance, Department of Health, PAGCOR, PCSO, and the Philippine Health Insurance Corporation, created under Joint Circular number 001/2022, where they monitor
The PAGCOR, the PCSO, vis-a-vis the subsidies, the PAGCOR, the PCSO, vis-a-vis the subsidy given by government. Doon natin makikita, we can see there if actually the amount collected is lower than the subsidy given to government.
we will do that,
To
yeah, Your Honor.
Can you please
And-
submit that
yes.
for the past 5 years?
And if I can also plead, Your Honor, for the court to be more understanding of PhilHealth for its its inability, I think what it was referred to as lack of absorptive capacity earlier, because we must understand, Your Honor, that the PhilHealth funds are not like discretionary funds. They can only be spent after PhilHealth has adopted the programs, goes through a process of developing adjustment to benefit packages.
Basta pwedeng Justice.
Thank you, Counsel.
Thank you, Your Honor.
Thank you, Justice Ko.
Thank you, Chief.
May we call Justice Japardi Mampao for his interpellation? Go ahead.
Thank you, Chief. May I ask the counsels for petitioners in GR numbers 274, 778, and 276-233 to answer these questions on procedural issues.
Good afternoon, Your Honor.
Good afternoon. Under Article 8, Section 5, Paragraph 2, Subparagraph E of the Constitution, the Supreme Court exercises original jurisdiction over cases in which only a question of, in which only an error or question of law is involved. Relatedly, the Supreme Court previously decreed that funds levied for special purpose can only be paid out for such purpose. This was the ruling of the court in the case of PCGG versus Cocopet, jar number 147-062, promulgated on December 14, 2001. In this case, the special fund in question is the 80% allocation from sin tax collections. However, it cannot be said that Philhealth funds, particularly those determined as fund balance, do not exclusively come from the sin tax collections. In this regard, would not your petition involve a question of fact that would require the court to receive evidence to determine the portion of that fund balance of Philhealth that pertains to the government subsidies from sin tax collections?
The question is if this is a factual issue, Your Honor. Well, we submit, Your Honor, that this is a legal issue of whether or not the reserve funds under the GAA should be transferred contrary to the express provisions, Your Honor, of the Universal Health Act that reserve funds should not be transferred back to the National Treasury.
You mean to tell us that such portion of the Philhealth fund balance can be determined from that 80% allocation from sin taxes without presenting any evidence?
Your
to
Honor,
that effect?
the express provisions of the GAA, Your Honor, refers to reserve funds, Your Honor. And the express provisions also of the Universal Health Code refers to reserve funds. So we are of the opinion, Your Honor, we submit, Your Honor, that these contrary opinions, these contrary rights, Your Honor, is the actual case or constitutional case in question, Your Honor, that the provision is contrary to law, contrary to the Constitution, also that the transfer also of the fund authorizing the Department of Finance to transfer is likewise unconstitutional because only the Constitution only allows the President, the head of the legislature, the chief, and the constitutional bodies to transfer reserve funds from one department to the other, Your Honor.
Are you in effect invoking the ruling of the court in the case of Jusamar versus the OTC, wherein the court emphatically declared that the determinative test in raising a petition before the court is that it must raise a question of law?
Yes, Your Honor, part of it is a question of law and the actual case in controversy, Your Honor. In such case, the actual case in controversy, in this case, Your Honor, as stated, is the conflict of rights between the Constitution alleged by the executive and the legislature to transfer funds vis-a-vis the express provision of the Constitution limiting the transfer of funds to the certain individuals, and also of the express provisions of the law prohibiting such transfer of reserve funds back to the Treasury.
Do you consider this case before this court as one of transcendental or paramount importance?
Yes, Your Honor, we submit that in our pleadings, Your Honor, that it is of transcendental importance and that the transcendental importance have given due course by this honorable court in a number of cases. And the health and welfare of the people, Your Honor, the transcendental importance of the basic right to health has been actually passed upon by this court in the case of Imbong, Your Honor.
May I now ask you substantive questions? Petitioners in GR numbers 274, 778, and 276, 233 argue that Section 1, Paragraph D of the 2024 General Appropriation Act and the Department of Finance Circular 003-2024 are unconstitutional for being violative of the constitutional right to health enshrined in two constitutional provisions. Article 2, Section 15, which states that its state shall protect and promote the right to health of the people and instill health consciousness among them. The second one is Article 13, Section 11, which provides that the state shall adopt an integrated and comprehensive approach to health, which shall endeavor to make essential goods, health, and other social services available to the people, to all the people at an affordable cost. In the landmark case of Imbong versus Ochoa, GR number 204819, promulgated on April 8, 2014, the Supreme Court categorically declared this as self-executing provisions, and there is no need for legislation to implement the same. Still and all, it bears noting that the so-called threat to the right to health is rooted in the actions of both Congress and the Department of Finance that appear to stymie or impede the timely implementation of the universal health care system. Does the characterization of the constitutional right to health as self-executing provision mean that Congress would no longer have discretion to determine how it should promote the same?
Your Honor, the express provisions of the Universal Health Care Law is very clear, Your Honor. The specific amounts to be given to the health care is basically outlined in the Universal Health Care Law, such as already mentioned, taxes, PABCOR, PCSO. That is not for the Congress to decide, Your Honor. That has already been passed. Second, Your Honor, the provisions of the Universal Health Care Act, Your Honor, is very clear as to the benefits and provisions and how the reserve fund would be spent should there be any excess, if any. In addition, Your Honor, we also agree that the GAA, contrary to even with the DOF circular, is again contrary to law and does not go with the intent of the Constitution for as you said, automatic implementation of health care for the Filipino people. So we submit, Your Honor, that again, even without the law, it is automatically given, but with the implementation of the law for both the universal health care, then it not only automatically gives it, but the specific provisions and amounts are very clear and should be followed, Your Honor.
Though these constitutional provisions necessarily entail the implementation of the universal health care system such that any threat thereto can be deemed violation of rights or the Constitution?
Your Honor, if I may, the Universal Healthcare Act was primarily passed in pursuit of these constitutional mandates. Aside from the Universal Healthcare Act, there are actually other laws that were passed to so that these constitutional mandates are met. Your Honor, while the language of the Universal Healthcare Act is clear, we also take note, Your Honor, that what the government did by removing or getting again the money they originally gave as subsidy for premium contributions of the indirect contributors, Your Honor, is a retrogressive measure, which under, and I believe was mentioned earlier, under the WHO and the UN documents, is actually, Your Honor, a violation of the right to health.
Let's talk about Philhealth funds. Do you adopt the postulation that Philhealth funds are public funds?
Your Honor, no, the funds that goes through Philhealth, Your Honor, even the premiums from the indirect contributors actually loses its character as a subsidy, Your Honor, precisely because of the social insurance scheme wherein there will only become one fund. And this fund will be used primarily for health services or for the health needs of the people, Your Honor. Despite the fact, Your Honor, that the indirect contributors' premiums are paid for by the government, there is a social, I'm sorry, Your Honor, when the original PhilHealth law, which was Republic Act 7875, was first amended in 2013, I believe. There was a clear mandate that there is a social contract between the government and the people, wherein the government will have to pay for the premiums of those who cannot afford to pay, while those who have the capacity to pay pays for their own premium. And the government, by removing the at least 60 billion, Your Honor, as of this date, the 60 billion removed by the government from the indirect funds are actually a violation of the one fund policy that is the basic concept of a social health insurance, Your Honor.
Do you recall the authoritative definition of public funds? The Supreme Court had occasion to define public funds in the case of Confederation of Coconut Farmers Organizations of the Philippines, Inc. versus Aquino III, CR number 217-965, promulgated on August 8, 2017. There, the court defined public funds, and let's check whether your theory is correct. Now, I will define public funds in the manner the court defined the same. Public funds are monies belonging to the state or to any political subdivision of the state, more specifically taxes, customs duties, and monies raised by operation of law for the support of the government or for the discharge of its obligations. Do you admit that these health funds may come from taxes?
Your Honor, there are taxes levied for the indirect contributors. We agree, Your Honor. However, there are also private funds coming from contributors from private entities, such as everybody here in this room, Your Honor. And the one fund concept would put it into, I would say, a trust fund, Your Honor, contrary to a public fund strictly stated by the Honorable Justice, Your Honor.
Under Republic Act 10351, otherwise known as the syntax law, it provides that 80% of the syntax collection, of the balance, the remaining balance that may be derived from syntax collections, derived from this act, shall be allocated for
Fund as the government being Philhealth only a trustee in possession of the trust fund given by the beneficiaries and the contributors for Philhealth.
Now let's talk about special fund. The reserve fund mentioned in Section 11 of Republic Act 11223, as Universal Health Care Act. Can you consider that as a special fund?
Yes, Your Honor. It is a special fund, Your Honor, because it is for a special purpose.
The fund that is derived from the syntax collections, will that qualify as a special fund?
Yes, Your Honor, because under the Republic Act 11346, which amended Republic Act 10351, the law specifically mentioned that these funds, the percentage, the 80% of the total collections must be used exclusively for Philhealth, for universal health care under the Philhealth.
Do you recall or are you aware of a jurisprudential ruling regarding special fund? I'm asking about decision of the court.
I believe, Your Honor, the mention earlier about the case of COCOFED versus
Yes.
Aquino discusses the special fund, Your
Although
Honor.
that pertains to COCO levy funds. Now, what's the ruling of the court in that case? COCO levy funds, according to the Supreme Court, are special funds allocated for a special purpose and cannot be used for other purpose other than for the benefit of the coconut farmers or for the development of the coconut industry. That's the ruling of the court. Can you apply that to this case?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor. In the same line, Your Honor, the special fund for the health.
Even after it has been allocated for that purpose, special purpose?
Your Honor, the special fund as collected, once given to Philhealth, should be allocated for the health and welfare of the Filipino people, the beneficiaries, both direct and indirect beneficiaries, Your Honor.
The 2025 GA has recently been passed into law. Has that provision on fund balance of the government-owned or controlled corporations been carried over?
As per our checking, Your Honor, it is not carried over in the 2025 General Appropriations Act, Your Honor.
The petitioners claim that this special provision of GAT 2024 is not valid or void because it violates a statute, specifically Section 11 of the Universal Health Care Act, Republic Act 11223. But if you read the provision, it does not mention about Philhealth Fund. It merely refers to government-owned or controlled corporations in general. If you read the Department of Finance Circulars 003-2024. It likewise does not likewise mention about Philhealth. It is only mentioned in that letter to Philhealth. In your petition, page 16, I refer to petition year number 274778. You only mention that, Exhibit E, Annex E. Now, my question is, from this instance, given this foregoing, are you not questioning the implementation of the law rather than the constitutionality of the law?
In our submission, Your Honor, we asked the constitutionality of the law because the DOF circular allows the implementation of the GAA and allows the Secretary of Finance to transfer funds from one department to the other. Constitutionally, Your Honor, as already mentioned, only the President under the executive may transfer funds from one department to the other and not the Secretary. We would also like to put on record, Your Honor, under our petition, we have a letter to the Secretary dated 27 August 2024, specifically asking that said transfer would be illegal and should not be implemented. And until today, Your Honor, we have no answer to our letter, Your Honor, addressed to the Secretary.
Suppose we harmonize this provision in the 2024 GAA with this law, Universal Healthcare Act, and this reserve fund should remain untouched. Would you still claim that there is improper implementation of the law?
We submit that we cannot harmonize. These are two conflicting provisions, Your Honor. It cannot be harmonized because specifically stated that it is only for the purposes intended. And if they are trying to skirt the law by passing the GAA and putting a provision that would allow a transfer to us that cannot be statutorically harmonized, Your Honor, and the GAA would be violative and invalid, Your Honor.
Thank you. May I now ask Chairman Neri Javier Colmenares, because in your petition you raise this President certification and this bicameral conference committee. Am I correct?
Yes, Your Honor. Thank you.
I could vividly recall last February 25, you manifested in my petition, I raised these two issues. Now I will ask you on this.
Yes, sure. Thank you, Your Honor.
Article 6, Section 26, Paragraph 2 of the Constitution provides that the President may certify to the necessity of the immediate enactment of a bill to meet public calamity or emergency. Do you know the case decided by the court which delved into this certification by the President regarding the urgency of a bill?
Yes, Your Honor. Well, if you're referring to the case of Tolentino, Your
Yes,
Honor, it was cited there.
Tolentino et al. Versus Secretary of Finance, 115455, promulgated on August 25, 1994. The basis for such certification has been challenged in that case. And this pertains to the certification of the urgency of the passage of the expanded value-added tax law, Republic Act 7716. The court found that the Senate did not find any need to controvert the same, and in fact, it accepted such certification. My question is, the House of the Philippine Senate and the House of Representatives sitting in plenary accept that certification of the President in this case?
Yes, Your Honor. From the records of the House and the Senate, the House and the Senate accepted the certification of the President, there are objections, of course, Your Honor, from some senators. But I think, Your Honor, the issue of whether or not the House or Congress accepts the certification is not going to overturn a constitutional violation. In this case, Your Honor, while the President has the discretion to issue a certification of urgency, Your Honor, it's not a boundless discretion, Your Honor, that the Constitution, because the Constitution put in parameters, Your Honor. The first is that there is a public emergency or a calamity, Your Honor. And second, there is a bill that meets this public emergency and calamity. And third, there is a need for the immediate enactment of this bill to meet such calamity. So therefore, Your Honor, in our interpretation, the President must follow this. Notwithstanding whether Congress agrees with it or not, if the President did not follow the parameters under the Constitution, for example, he issued a certification absent any calamity or emergency, or he certified it despite the fact that there is no immediate enactment of the bill, then for us that is violative of the Constitution, Your Honor. So in this case, we argue that the President issued the certification, but from the records of Congress itself, there was no emergency or calamity to speak of. And Your Honor, the reason for our interpretation of this, other than the fact that the certification did not mention any calamity, so that at least Congress can exercise its discretion to accept or not accept the certification, the timeline itself, Your Honor, from congressional records show there was no calamity. They approved the bill, Your Honor, on second and third reading on September 27 of 2023. And then they had a recess on September 30 of 2023. They did not transmit the bill to the Senate despite the fact that it's supposed to be an emergency or public calamity. They only transmitted it, Your Honor, in November. So they approved it on September 27. They deviated from the constitutionally required legislative process. But then after all the rush, Your Honor, they took a recess. And then they transmitted it November 4. Then we realized later on the reason for that hiatus is because they formed a small committee to amend the bill already approved on third reading, Your Honor. So that was the reason why they had to wait for November 4. Publicly, the small committee declared, oh, don't worry, the small committee will finish all the amendments by October 10. But then they failed, so it's November 4. Then there is the BICAM, Your Honor. Then they created a technical committee. All these things, Your Honor, we believe, does not show emergency or a calamity, Your Honor. And secondly, Your Honor, if Congress is going to delay the approval of the budget on the basis, oh, we're going to have a recess, we're going to form a small committee, and so on, it is a self-created emergency, Your Honor. The President cannot certify a self-created emergency. Ginawa nyo yun, bakit ako ang magsicertify sa kasalanan nyo? It cannot even be a preemptive emergency, just in case Congress will not be able to pass it in December, so I'll just issue a certification in September. It cannot be preemptive, Your Honor. The certification of the President as to a public calamity or emergency must be existing at the time of the certification, Your Honors. So in that case, Your Honor, the President or the certification violated the parameters of the Constitution. There was no calamity. There is even no immediate enactment, Your Honor, because whatever the President do, it will only take effect on January 1 of 2024, so much so that whether or not he certifies it, the immediate enactment is not forthcoming as required by the Constitution, Your
Having
Honors.
said a while ago that it was accepted by the Philippine Senate and the House of Representatives, is that not within the realm of, are you not questioning the legislative wisdom behind such acceptance of that certification?
Your Honor, no, Your Honor, because legislative wisdom can only be considered if there is no violation of the Constitution. In fact, Your Honor, this is very strange. Presidents issue certification. They did not explain to the Congress what calamity I'm addressing, how will this bill meet the calamity, and yet Congress blindly follows the certification. I have a suspicion, well, beyond this case, Your Honor, in fact, for them, ano ba itong emergency na sinasabi ng Presidente?
Now let me now ask you about bicameral conference committee.
Thank you, sir.
Do you recall decision of the court that made mention about this BCC, bicameral conference committee, Abacada Guro party list
Yes, sir.
versus Ermita?
Well, I've read the
GR number 168056 promulgated on September 1, 2005.
yes,
The
even
Supreme
Tolentino
Court,
mentioned that, Your Honor.
said in that case that this BCC is mandated. The court, in effect, recognized that to settle these diverging or disagreeing provisions in the House and Senate bills.
Yes, Your Honor. There is
Are you against this BCC or bicameral conference committee?
No, Your Honor, as long as they follow the Constitution. In the Constitution, for example, Your Honor, appropriation bills should exclusively originate from the House. And the role of the Senate is to propose amendments to the bill. 281 billion unprogrammed fund from the NEP submitted by the President, 281 approved by the House, 281 approved by the Senate. The Senate did not propose any amendments to the 281 billion. Suddenly, Your Honor, the BCC proposes 431 billion, half a trillion, Your Honor, of items and projects in the unprogrammed fund. So did that originate from the House? No, Your Honor. It originated from the senators and the members of the House in the BCC. Was it the proposal of the Senate? No, Your Honor. The Senate did not propose amendments to the 281 billion. So even the senators in the BCC have no power to propose amendments. The BCC, Your Honor, cannot propose amendments to that already approved by Congress and the Senate because the BCC is not the Senate. And the Constitution says the Senate may propose.
You mean that BCC cannot introduce new provisions?
They can introduce harmonization, as you mentioned, Your Honor. If Congress says 281 billion and the Senate says, let's make it 300 billion, the BCC can now harmonize the two provisions. But in this case, Your Honor, the House said 281, the Senate said 281. So where did the 739 billion come from? It came from them, Your Honor. So they have no authority to propose it. This is ultra vires, Your Honor. It did not originate from the House. It was not a proposal of the Senate. If it's ultra vires, no amount of ratification, Your Honor, can cure an unconstitutional act.
Okay,
So, thank you, Your Honor.
I got your point. Let me ask you about the application of this very popular doctrine of operative fact.
Yes, Your Honor.
Assuming that your petitions are deemed meritorious, will the application of this doctrine of operative fact prohibit the return of the money transferred to the National Treasury?
Well, Your Honor, of course, it's at the discretion of the court. But for us, at the very least, the 479 billion of new items inserted by the BCC should be returned. And those funds which were spent with bad faith, for example, Your Honor, there was a TRO issued, and yet the Philhealth funds transferred were still spent despite the TRO or after the TRO. And I think they should be returned. The entire Philhealth fund should be returned, Your Honor. Well, the 479 billion, Your Honor, if there is corruption attendant to the bills, I would like to think that they should be returned, Your Honor, at the very least. But we leave it to the discretion of the court in this case because ito yung problema, Your Honor. They placed us in a corner. Gawa-gawa ng iilan, everybody's affected. I mean, if you're going to ask would the entire budget must be voided, then everybody's affected, even the court. Gawa-gawa ng iilan, lahat tayo, ngayon nakalagay tayo sa pader, Your Honor. Kaya minsan mapilitan na lang tayo mag-operative fact. Siguro, Your Honor, if the court is going to exercise the operative fact doctrine, at the very least, the parameter should be issued para wag nang ulitin. Kasi otherwise, pag inulit nila yun, Your Honor, malagay na naman tayo sa alanganin, mag-operative fact na naman ulit tayo. They've cost hundreds of billions of pesos to the Filipino people. And lulusot lang sila because of the operative fact, nagastos na namin. I mean, Your Honor, I am now in no conscience to say na sige na tanggalin, ibalik lahat yan. Siguro the court will have to do this as declared by the court, sparingly, case-to-case basis. But for me, if there's bad faith, if there's corruption, the court must order its return, especially the entire Philhealth Fund. For example, Your Honor, 89 billion, that's clear from the questions of Justice Ko, and other funds that may have been attended by corruption, Your Honor. In any case, Your Honor, whatever is the decision of the court, if there is an irregularity or corruption, people must go to jail. People must be charged for this insertion of 500 billion peso in the budget of the program appropriation, merely because it's their whim, not because the House said so, not because the Senate proposed it, but because they felt they know of items that nobody ever thought of, not even the President, not the House, not the Senators. They, by their lonesome, the BCC Senators and the House of Representatives thought of these items that nobody thought about. For us, Your Honor, that is not only arrogance, that is a usurpation of the powers of both houses of Congress, Your Honor.
This is what the doctrine of operative fact says. It nullifies with law, but sustains its effects.
Yes, Your Honor, in exceptional circumstances, Your Honor.
So it does not apply to this case?
It is the court's discretion to apply. But at the very least, Your Honor, we would like to assert at least yung 479 billion. Sana masoli man lang yun. Kasi talagang void yun eh. Ultra vires talaga, Your Honor. But of course, we leave it to the court. Ang limit lang namin, Your Honor, is this. At least the billions of pesos taken from Philhealth and the billions of pesos taken from PDIC, I heard it, I read it's 100 billion pesos taken from the Philippine Deposit Insurance Corporation. They should be returned, Your Honors, because these are very important to the right to health, as my co-petitioner said, and even the security of depositors, Your Honor. You take 100 billion pesos more than what was taken from Philhealth in PDIC. These things, Your Honor, there must be a lesson taught here, Your Honor, and they must be, the court may order the return. It is the burden of the respondents to prove that they did it in good faith, there was no irregularity, no corruption. Then the court may, of course, we submit to the court's discretion on this matter, Your Honor.
Thank you. May I now ask the
Thank you, Your
counsels
Honors.
for respondents?
The PhilHealth funds was not discussed in relation to operative fact. Can we add to what my colleague has pointed out? The operative,
proceed.
Yes, Your Honor. Thank you very much. The operative fact doctrine is based on, the court says it should look at the effects and rule based on equity and fairness, because it's a rule on equity. So you have to show the one who implemented the law, did they do so in good faith? we will point out the government's action have budgets of bad faith. But before that, Your Honor, let's also look at the effect. Is it equitable? Is it fair to the people when they took away the PhilHealth funds? Clearly, it's not, Your Honor, because the law clearly says those funds are for the health of the people. And our people, if we look at PGH, just right in front of the Supreme Court, early in the morning, hundreds of people line up because they cannot afford health care. They have to line up in our government-funded hospitals because they have no choice. PhilHealth should have provided that choice. So it would be inequity if we do not return the money. Now, did they took the money in good faith? No, Your Honor. Why? The law is clear. They should not have taken it. Then we go to COA. Let me point to the COA observations published in the COA website for GOCC's 2023. Your Honor, when they took the money from PhilHealth, it was actually triple whammy on the PhilHealth members. Why? Number one, they took the money in contravention of the law. Number two, when they took the money, their computation was wrong. The COA was saying the 89.9 billion, even assuming the computation is correct, is even assuming that their formula is correct, rather.
May I remind you that my time is very limited.
Sorry, Your Honor.
Please expound that in your memorandum.
Yes, Your Honor.
Please.
Thank you very much, Your Honor, for giving us the opportunity.
Thank you. May
Mr.
I
Counsel?
now ask the
Mr. Counsel, may I call your
counsels
name?
for respondents.
Anong pangalan niya? Mr. Ocampo? Mr. Ocampo, next time you seek the permission of the court before you speak. You just don't butt in there. Thank you.